We go on and get started. Good afternoon, everyone, and welcome this Friday afternoon on the Zoom. We appreciate you being on the call. Our president, Mr. Don Bruner with BRG Apartments, is going to be running just a little behind. We apologize for that. He apologizes, but we do want to turn it over to Jeff Greenberger, our parliamentary for the board of directors, and Charles Tassel, our director of governmental affairs. So, guys, take it away.
So I'll start us off because I'm going to pass it over to Jeff for the most part. As you guys know, on September 1st, the CDC came out with its update, and the ruling or edict on high was an eviction moratorium across the board, across the country, on those who could not pay. Ideally is what it's targeted for, but it seems from looking at the declaration that a resident would have to fill out that it is even simpler than that. It's that they don't want to pay and they have to verify it. They just put it in there. And then it gets into issues of everything from discovery to how do you know, and proof on one side with, well, there's a simple fact of they said it, so therefore it's legit and I can't move forward with an eviction, or what our next step is. And let me back up a couple of steps even, because on August 8th, actually the president came out with a couple of different directives. There were 4 different directives. One of the directives actually addressed HUD and then also addressed the CDC. Industry-wide, it was expected that there would be some response that the CDC would have on evictions in cases of, if there was a high infection rate, high mortality rate in specific areas. In part, that would be consistent with what the administration at the federal level has said. They want to see hotspots addressed at the county level, at the local level, even at the state level. This CDC ruling goes against all of that. It literally says whether it's Batavia or Boise, Idaho, they're all getting addressed exactly the same. Needless to say, that has caused no small amount of consternation in the industry. The Housing Coalition has reached out both to congressional, Senate side, as well as to the administration. There's open communications, there's back channel communications, there's any kind of communication we can get. And I will mention to you, you should have received a voter voice outreach from NAA. Please make sure you fill that out. Go to it. Go look in your inbox even while you're on this call. It's a real simple thing to fill out. And the reason for that is there's a couple of things that are going on. This voter voice outreach puts pressure on individuals, specifically the representatives and the senators who haven't done their job in resolving and coming to some sort of conclusion. As you guys know, initially there were about 3 different CARES Acts or 3 different programs passed, the CARES Act being the last one, and there was a modification to that even in May. But since that time, of early May, they really haven't passed additional legislation. So what was expected to pass in June is still somewhere in a gulf between the House and the Senate, with the White House weighing in, somewhere in the neighborhood of $2 to $2.5 trillion difference in what their agreements are. One of the key pieces that NAA is focused on is saying, as you get to narrow that gulf and you start to work to some solution here, hopefully in the next month, maybe 2 months, make sure that rental assistance is a key part of that. Our conversation all along has been rental assistance is the first domino. If that is not addressed, then all of our bills that cannot be paid are the next set of dominoes that fall, and it leads to a housing instability that will make the 2008 recession look like just a little walk in the park compared to what's going to happen. That CDC ruling is going to exacerbate it. There are already property owners, those of you who do tracking on whether it's a LoopNet or properties are for sale, brokers are getting more conversations. They're starting to have more conversations from landlords who have been in this for a long time, property owners and managers saying, I'm done, to smaller owners who are saying, I can't afford this. That's the situation we're dealing with right now. I literally was on a call on eviction prevention earlier this week, and Santa Maria Group, talking with legal aid, said this can't go the way it's going because literally we've got small owners. If they don't get some money coming in, the rent's coming in, they're going to go under and our people are going to lose their housing. So, it's careful what you ask for, you may get it. Some of these progressive groups have asked for this kind of a eviction ban. Now that it's in place, they're realizing that this could actually be much more detrimental than was originally intended. Maybe it wasn't intended to be detrimental, but it is by its very nature. So with that, and I think I'll put words in Jeff's mouth here for a moment. Every court that we're hearing, and we're hearing from across the country, states are handling this differently, counties are handling this differently, courts by precedent are handling it differently, and even judges are handling it differently. So the uniformity that was kind of set out at the federal level is absolutely not uniform when it comes to the local level. So with that wonderful opening start, what I'll do is turn it over to Jeff to kind of start for our next, where we're going from here and what to do. And I will encourage you, talk to your attorneys. Do not just wade into this, because the fines and the fees are absolutely unbelievable. Just for perspective, the Ohio Supreme Court did come out and reiterated that as an individual, you can be fined up to $100,000 and a year in jail if you do this incorrectly. That also, if that person moves out and has some sort of mortality incident, they die, whether it's related to COVID or they get hit in a car wreck, that fine doubles. And the organization that you're a part of can be fined anywhere from $250 up to $500 if the person dies, $500,000. These are not lightweight issues. So with that level of gravitas, and hopefully everybody listening, I want to turn it over to Jeff Greenberger to kind of help lead us through this maze.
What a lead in. Thanks. Well, so thank you, Charles. And as always, before I start one of these things, I always have to remind you, while I am a lawyer, and the advice the information I'm going to provide you, because of the nature of this, cannot be considered legal advice today. We always insist that you must consult with your own legal counsel before taking action today. In order to be able to provide this to you today, I cannot allow this to be considered an attorney-client relationship being established today. Supreme Court insists I tell you that. Before I dive into this, let me just remind you of a couple things that are 7-8 months old. If you were a CARES Act property before the CDC moratorium came out, you are still a CARES Act property today, right? So if you were required to serve a 30-day notice to even start an eviction before all this stuff came out, you still are required to serve a 30-day notice to start an eviction. So please don't lose sight of all that in what I'm about to tell you, because some people are like, oh, well, at least the 30-day notices went away. Nope, you still have all that other stuff. If you were required because of you were a Section 8 voucher recipient tenant, or you were a Freddie Fannie mortgage property, you still are under all those restrictions. On top of that, this moratorium came out. Now, the term moratorium is sort of strange. So let me take you back about 4-6 weeks ago. President Trump signed a bunch of executive orders. One of those executive orders he called an eviction moratorium. And when it came out, I had a long weekend and I was waking up early on a Saturday morning to see what it was. And I was so relieved to see that the eviction moratorium didn't do anything. It just said the CDC and HUD and a couple other organizations are charged with looking into whether an eviction moratorium would be beneficial to avoid spreading COVID. And I called Charles that Monday morning and I said, did I miss something? Did I sleep through something? And Charles said, no, here's what we think is going to happen. We think that some form of the CARES Act moratorium on evictions that was really preventing evictions more than just the 30-day notice is going to come back in hotspots, as Charles said. I'm like, all right, well, I guess that's not as bad as it could be. And Charles said, well, we'll wait and see. We don't know. And I started calling my clients and saying, well, look, let's get started on filing evictions while we can. Get while the getting's good. And we were just about on the precipice of getting to be able to file evictions under these 30-day notices. And bam, the CDC issued this moratorium, which now requires us to look and see if our tenants serve us with a declaration. And if they do, we may have to stop evictions. So let's talk about what this moratorium means to you. And we sort of have to divide it into sort of two different branches. But let's talk about this declaration first. The declaration, first of all, even though it is being misinterpreted by some courts, the way the Federal Register lists this declaration from the CDC, it's only supposed to apply to non-payment of rent evictions. Okay, that means something, especially if you're a non-CARES Act property. This at least allegedly clears up for us that we could now proceed again with evictions for other violations, right? If a tenant is standing on, and this is a real case, standing on their balcony, throwing vomit at other tenants, and they say they're COVID positive, we should be allowed to evict that tenant. Also, if they're peeling their drywall off and trying to get at the wires because the Martians are talking to them through the wires, yes, we should be allowed to evict them. We also should be allowed to evict for other violations, and in theory, we should be allowed to evict just because leases have expired. We should be allowed to do all those type of other 30-day notices for lease violations. We should be allowed to do the end of lease term violations. So in Kentucky, 14-day for violations, 30-day if you're in a non-IRTLA jurisdiction, and in Ohio, regular 30-day notices for everything other than non-payment of rent and criminal activity, drug activity that you'd serve a 3-day for. So this moratorium theoretically applies only to non-payment of rent evictions. Now, I've already seen judges taking these declarations for other things, and we're having some luck convincing judges to stop doing that. Other judges, quote, out of an abundance of caution, are taking these declarations for every eviction. We're going to have to see how that shakes out. But the act, the moratorium says they're only for non-payment. So theoretically, non-payment only are affected by these moratorium declarations. Now, the declaration is supposed to be executed under the penalty of perjury, which, again, I don't think you're going to find any judge or magistrate that wants the headline that they threw a tenant in jail for purging themselves by wrongfully signing one of these things, but we'll see. And they're supposed to say, they're supposed to sign off that that there's a couple things that they've done to avoid eviction. And essentially, they are supposed to say under the penalty of perjury that they have used their best efforts to obtain all available government assistance for rent or housing. Not some, not one, but any and all available. They also have to certify that they expect to earn no more than $99,000 in annual income for calendar year 2020 if they're a single filer, or $198 if filing a joint income tax return. And they are not required to report any, or they were not required to report any income in 2019, or that they received an economic income payment, their stimulus check, under the CARES Act. Now, that is not, we believe that is not, extra $600 payment. But if they receive that $1,200 stimulus check, they're apparently, at least as I understand it, they're not eligible for this CARES Act, excuse me, the CDC moratorium. It's going to be a tough one to prove, but we're going to ask these questions. Here's the one that we're having some luck with. I'm unable to pay my full rent or make a full housing payment due to substantial loss of household income, loss of compensable hours of work or wages, layoff, or extraordinary out-of-pocket medical expenses. And I'm using my best efforts to make timely partial payments that are close to full payment as my individual circumstances permit, taking into account other non-discretionary expenses. This is the one that is the squishy one. If evicted, I would likely become homeless, need to move into a homeless shelter, or need to move into a new residence shared by other people who live in close quarters because I have no other available housing options. They also need to certify that they understand they must still pay rent or make a housing payment and comply with other obligations that they may have under their tenancy, lease agreement, or similar contract. They further understand that fees, penalties, or interest for not paying rent or making a housing payment on time as required by the tenancy, lease agreement, or similar contract may still be charged or collected. I'd like to talk to Governor Beshear about that one. I further understand that at the end of the temporary halt on evictions on December 31, 2020, my housing provider may require full payment of all payments not made prior to and during the temporary halt, and failure to make my payment may subject me to eviction under state and local law. Okay, that's what they're signing under the penalty of perjury. There's a lot to unpack there. Now, I said a few minutes ago, we have to break that into two branches. The first branch is there are tenants who may serve that on you prior to you filing the eviction. And on that one, right now, we're feeling kind of stuck. Because if they serve that on you before you file an eviction in court, there's not a lot we know to do with that right now. And that's because of what Charles said a couple of minutes ago. If you get served with that and you then go and file an eviction, there's some question about whether that would put you in peril of that $100,000 1 year in jail penalty. Now, personally, I'm not so sure that it does, because the definition of an eviction under this moratorium really seems to be more about the lockout or ejectment part of an eviction, not the filing of an eviction. But so far, none of my clients have been comfortable enough about the risk of a $100,000 fine and a year in jail. And by the way, that would also apply to me, $100,000 and a year in jail for me too, that we're interested in filing evictions if you are served with that statement before you file the eviction. So none of my clients and we are not comfortable filing evictions for you if you are served before you file the eviction. Okay? So if you're served, you're kind of stuck right now. Now we're working on some ideas about how to get those things maybe in front of a court by, we got lots of ideas, maybe taking a deposition of the tenant or something like that, but all that's time consuming and expensive. And we're kind of hoping that there might be some litigation brought to challenge this moratorium, and that might be the way to go. So we treat getting these evictions for non-payment of rent filed as a race to the courthouse. That is, if we can get the eviction filed before you are served with one of these forms signed under the penalty of perjury, that gives us an avenue. And what most courts are doing is they are allowing us, if you are served after the eviction is filed, they're giving us a right to ask questions of the tenant under oath in court, sort of like a cross-examination. And my partner, Kevin Brewer, and I have been asking those questions, along with other lawyers, have been allowed to ask those questions in almost all the courts we appear in Southern Ohio. We've had a little less luck in Kentucky, but I will give credit to some of the judges in Kentucky. The judges in Kentucky have been much more active about handing out these forms. In Kenton County, Kevin tells me that the judges have been handing them out before eviction hearings and asking people, basically tenants, to sign them and stopping the evictions. Now, I will give credit to Judge Smith and Judge Thomas and Boone. That's exactly what they were doing too. But Judge Smith actually, when I asked him after he handed the forms out and basically tried to stop one of my evictions that way, I said, Judge Smith, a lot of judges are allowing me in other places to ask questions of the tenant. He said, okay, I will allow you to ask questions. And after that, he allowed Galen, is it Thomas, I think, another eviction attorney? He allowed Galen to ask questions of that tenant, and he did allow evictions to actually, he actually allowed us to ask, and he allowed a case to go forward. And then he said he would actually consider, if a tenant didn't show up after serving one of these forms, to have a 7-day show cause hearing. So I'll give credit to the Boone County judges. They're actually rethinking these things and allowing us maybe to get a chance to ask these questions. I know Judge Blau in Campbell County is thinking the same way. I cannot speak for the Kenton County judges and how they're thinking, but hopefully we will get that. But I know Hamilton County is allowing it. I know Claremont County is allowing it. I believe the Butler County judges are treating it the same way. Essentially, the Ohio judges that I've talked to are magistrates, and I had a conversation, again, not ex parte about a specific case, but with Magistrate Condit the same way. They're allowing this to be more of an affirmative defense. They may be, asking tenants, but they're making the tenants raise it rather than handing them out and saying, here, look at this, sign it, so you can avoid your eviction. So that's what we're hoping. But either way, even if they're handing them out, they're allowing us to ask the questions. So Kevin and I and my law firm have been allowed to say, all right, you've signed this. Now, what federal aid have you looked for? What housing assistance have you asked for? Okay, you have or you haven't. Now, what do you do for a living? How much money did you make this month? And what have you spent it on? I know Kevin had a case the other day where the tenant said, I made X dollars. What have you spent it on? My phone bill. Your cell phone bill? Mm-hmm. Home phone, internet, cable. You've eaten out a couple times. And Kevin basically successfully argued that eating out and paying your cable bill weren't as important as putting a roof over your head. And that money should have gone to a partial payment of your rent. And since they didn't try to make a partial payment, the magistrate felt that that should allow the eviction hearing to go forward. So we think that's a way to successfully get these cases heard, not always won, but at least heard. And that's what we're doing right now. Now, again, the real way to successfully deal with this is for the National Apartment Association and their coalition of partners to challenge the constitutionality of this moratorium, but that's going to take some time and money and so forth. But in the meantime, that's what's happening today in courts around Hamilton, Butler, Warren, and Claremont counties. Kentucky's dealing with it differently. These things will continue to change and change without notice. Please understand that we don't win every one of those cases. And what seems to be happening when a valid declaration is being served, the courts appear to be continuing these cases out till early January 2021. We don't know what's going to happen if a federal court overturns this moratorium and how we're going to get those cases back on. Another very interesting development that we're seeing, which we don't know how to deal with quite yet, but we're going to learn over the next couple of weeks, is tenants, after writs are issued, are bringing these declarations down to the courts before set-outs. And so courts are granting stays to these set-outs, even though we got our writs. So that's another problem that we're learning to deal with, that have just started happening in the last 3 or 4 days. So these things are very, very difficult. If you thought the House always won in Vegas, we are really, really in a bad position with these moratorium declarations. Charles said that legal aid is should be a little more careful what they wish for, because these things are going to be very detrimental to your ability to earn a living and to be able to earn enough money to care for your buildings and earn enough money to pay your employees and so forth. And it really risks putting some of you out of business or putting you in very, very serious financial aid or peril. I will go one step further than that in a minute, but right now I have to believe legal aid is advising people to run down to the courthouse and serve you with these things. And if you've already won, run down and file these with courts to upset your writs. And so every day this is going to be a new and worse challenge for you all. And all we can do is just keep fighting it more and more, but the front is going to keep moving. And we don't know what magistrates are going to do day in, day out, and judges are going to do day in and day out as the front keeps moving. And all we can do is just keep fighting the good fight with it. I want to finish before I open it up for questions. I know that the question box has been filling up a little bit, and I'm sure Charles is chomping at the bit to add to this. I want to finish my thoughts with just one more thought, because part of this, well, I have two thoughts. One is I want to dovetail one thing Charles said, which is this whole thing, in my opinion, without getting political, is a result of without regard for political party. This happened as a result of Congress and the Senate's failure to act on any sort of bill to provide any sort of additional money to supplement any rent assistance or additional unemployment assistance or any additional money to fund government or anything. Because, once you throw an eviction moratorium, that's great. But without giving people money to fund anything else, an eviction moratorium in and of itself doesn't solve any problems. It doesn't prevent the spread of COVID any more than anything else. I mean, you can't say eviction moratorium and open the schools. Now, I'm not trying to get political here, but let's just take this one logical step further, right? If you all don't have money, and I was on an NAA conference call right when this happened, and they were talking to some senators who are supposed to be, I guess, some of the best and brightest people, because they are the highest body of legislative authority in our country. I think they're supposed to be bright. And the response back was, well, what do landlords care? If they don't have to pay their mortgage, what do they care? And the response was, they have other expenses, Senator. Well, like what? You ever heard of real estate taxes, Senator? They employ people, Senator, right? I mean, they have to upkeep these apartments, and that they didn't get unlimited mortgage forgiveness, right? Oh no, I didn't know that. Well, one of the problems we face here is that you have a real estate tax bill coming due. And if you guys can't pay your real estate taxes, think of all the things that get impacted by that, right? Schools, local government, roads, all the other things. If you can't pay your employees, what happens next? So without an extension of unemployment benefits, an extension, additional help to pay rent, as Jerome Powell said the other day, it doesn't do any good to just have an eviction moratorium and a foreclosure moratorium, because it's just going to create a bigger cliff, right? If all this stuff just goes into foreclosure, then the governments fail, the bond market fails. I mean, this is just a gigantic cliff. And so that call to action that Charles was talking about, it's not It's not just for the big operators here, right? Because the cliff isn't just an eviction cliff, and it isn't just a foreclosure cliff. This is going to be a real problem for local governments and state governments. It's a tsunami coming. And it's not just for us. And it really does. I mean, I was talking to some people who were like, wow, it really sucks for your industry. And I'm like, it doesn't just suck for our industry. It's gonna have a gigantic impact on all industries, on local governments, on schools. We really, really hurt the whole country if this industry starts to slip and fail. It's going to be much, much bigger than the mortgage crisis. So please help spread that word to others, because it is a big, big deal. Charles?
I'm going to say, Jeff, to that point, just as an update, there has been one federal lawsuit already filed that is really capturing the attention of the whole housing coalition. And that effort, it's actually done by it's not industry related, but they're looking at it from a precedent perspective. And I say this to your point about when this comes down to how broad of an industry effect is this, or is it multiple industries? I mentioned earlier about making the recession look like a walk in the park. There's also the precedent setting that if a president can, by, with the stroke of a pen, say, you know what, we believe this is a crisis, therefore we're going to stop this industry, or we're going to intervene, not just at the federal level, but at the state level and inside of contracts, which are constitutionally banned. Again, not an attorney, but from everything I understand and what I've been told, they're specifically not supposed to be doing that. And this bypasses all of that. What could come next? And that's where attorneys from other industries are looking at this saying, this is a huge problem beyond just the immediate issue that it's affecting the rental industry, it's affecting the multifamily industry, but the precedent that this has for our country is overwhelming. The next president that comes along and says, it's a health issue for so much smog out there, I'm going to ban all cars because it's a health issue. And there was a number of examples cited like that. The results of that, I mean, that's not how our country runs. It's not how it's supposed to run. And having said that, I'll go back to this right now. We have a deadline that this moratorium is supposed to go until December 31st of 2020. Greg Brown, with the Director of Government Affairs, Vice President of Government Affairs for NAA, and we were on a call, and he reiterated that there's not a strong urge, opinion, behind the scenes effort in Washington at this time to actually end it on December 31st. There is an expectation that it will continue. I won't go into the politics of it all, but there's a strong likelihood that this will continue beyond just December 31st. So making sure your paperwork, your documentation is correctly done is going to be absolutely critical. With that, Jeff, I know we've got questions, so why don't we start moving to some of that?
Jeff and Charles, if Michelle, if you could read some of the questions, just start at the top, and then let's, if you could answer those, Charles and Jeff, I'd appreciate it. Thank you.
Charles, you want to read them or you want me to?
Go ahead. I've got some of them on here, but I'm working off a small screen.
Okay. Patrick asked if, says, what if you provided them with government local assistance programs and they did not pursue?
Again, it's a declaration, it's not an affidavit. They say that I, meaning the declarant, have used best efforts to obtain all available government assistance for rent or housing. So it's going to be up, if we're allowed to examine or cross-examine the tenant as a declarant, that's going to be up to a judge to decide whether that meets the standard. Every judge gets to make those decisions themselves. We hope. I mean, some judges are, again, going to use that all abundance of caution example and give the tenants a lot of breaks. Remember, this whole thing is allegedly to avoid the spread of COVID, right? We don't evict you. You get to stay in the housing for free, so that you don't have to go somewhere and be exposed to COVID. One of the things that I've asked once or twice is, where would you have to move? Oh gosh, I'd have to move in with my parents. You see your parents a lot? Oh yeah, every Friday night. Well, are you really going to then be exposed to COVID? More than you already are? It's a question. One other thing I just wanted to suggest, and again, we're not soliciting business here by saying this, but one thing that we're doing for a couple of our clients, we're waiting to see the success of it, but one thing you can do that doesn't seem to be prohibited by this moratorium, you can sue your tenants for rent without evicting them, right? You can just go into court, sue them for, you owe me $3,000 back rent. You can't, you don't know what the future rent's going to be, but you can say, up to now, you owe me for $3,000. I want a judgment for $3,000, and maybe I'll see you again in 2 months for another couple $100,000 of rent. At least it lets them know that, when they finally move out, or when things, if they're still working, you can start garnishing them for that rent. Nothing prevents that. At least it tells them that they can't just sit there scot-free. You're not evicting them, but you're going to start garnishing them. For some of you, that might be more work than it's worth, but I really like the message it sends. Wait, you can't do that. Yes, I can. I'm not evicting you, but I am going to start collecting the rent from you. It doesn't work for everyone, but it works on some. And we think it might have an effective message to some people who think that they just get to sit there and it's free now. It's not exactly free. I can't evict you. You filed your declaration, but I'm not going to expose you to COVID, but I am going to expose you to garnishment. Might be a thought for some of you. Might work.
All right. Ginger asked, what does, in quotes, serve mean? What specifically does the resident have to provide to prove they are meeting the declaration? Is there a form, and where can they get a copy?
Oh boy, serve is a really tough one under this act. I'm not sure I'm in the best position to answer that, because I feel like the act is a little unclear about what that actually means. Okay, it says provide an executed copy. It doesn't really say what the word provide means. I would assume it means in some way make it available to you. I would assume it could mean hand, mail. I don't know what else it could mean. I'm assuming it's going to mean, I assume it's going to be construed very liberally. I would not contend that there is a prescribed form. The act sets up what it says. There is a website that I think has this form on it. I would hate to read it to you because it's some god awful thing, but I'm sure we could throw it up for people after this. Michelle, if you want me to send it to you, we could throw it up somewhere on our website, I would assume. But legal aid prints them up all day long now. The courts have them in their help center outside the eviction court. I know the Kentucky courts have them all over the place. I assume legal aid probably has it on their website as well. but I don't think it's a particularly prescribed form. I don't think there's, it has to say what it says, but I don't think it's a, a particularly magical form. I don't think there's a, a type size or a typeset or anything like it. It just has to say what the Federal Register says it's supposed to say. So I think we could probably download one from the from this website if we wanted one, but I don't really know that we want to make it available publicly for residents to download from our website, Michelle. I guess that'd be an apartment association decision, but I'm sure it's on Legal Aid's website.
We can probably have it on file here, and if anyone calls, we can send it out to them.
Yeah.
All right.
Sorry, I'm not trying to be sketchy about it or anything like that. I don't know if the industry wants to make it available for the public to download and make it harder on ourselves.
All right, the next question is from Alexis. She wants to know if they should serve their 3-day demand for quit or rent as well as the 30-day notice.
That's an interesting question. And, I see Dave Donette's on the line as well, on this call as well. And Dave and I do it a little differently. So if Dave wants to unmute and opine about this, we did not put the 3-day Ohio required language in our 30-day CARES Act notice because we wanted our landlords to be able to accept partial payments during the 30-day period. But I know Dave has put his 3-day demand or 3-day mandatory Ohio language in his 30-day notice. I think it's just a stylistic issue. The only difference is at the end of 30 days, we serve 3 days, and I think Dave's clients do not. Dave, do you want to unmute and say something? Guess not.
I don't know if he's on the call still. I think he had another appointment he had to go to.
The answer is if you do not want to accept partial payments during your 30-day period, you just have to put that magic language from your 3-day in your 30-day. That I'm paraphrasing, but it's you are being asked to leave the premises. If you do not leave, an eviction will be commenced against you. If you are in doubt regarding your legal rights, it is recommended you consult an attorney, something like that. I may not have gotten that exactly right, but that would then have to be in your 30-day CARES Act notice. If you want to accept partial payments during your 30-day CARES Act period, then you would serve a 3-day afterwards. If that doesn't make sense, whoever sent that, you could shoot me a message and I'll be happy to kind of deconstruct that a little bit more. I hope it makes sense.
All right, Lauren asked, have we seen anything that would indicate that our communities located in Kentucky should be handling this order any differently than our communities located in Ohio? For a time period, Kentucky's courts were closed to non-payment evictions, even after Ohio's opened back up. Are we aware of any differences in how Kentucky is applying this order from the way Ohio is, besides the allowance of declaration questions?
Oh gosh, yeah, Kentucky's doing things somewhat differently, but because it's Kentucky, not because of any other reason. The CDC order is a federal order, so it should be applied identically. But as we know, Kentucky is handing out these CDC declarations to all tenants at the beginning of the docket saying, if you want to sign it, and that might end your eviction hearing right now as you sit here. The other difference is the Kentucky Supreme Court has changed the way eviction hearings are going to be handled effective, I believe, Monday, the 21st. And that is now eviction hearings are going to be a 2-part process. Now, at least as we understand it, and obviously we haven't seen it yet because it's not going to start till Monday. Every eviction hearing in Kentucky is now going to be a 2-part hearing. You're going to go the first hearing and there's going to be no eviction hearing, and the court is going to advise tenants, I believe if I'm right about this, that the first part is going to be where the court's going to advise tenants of places where they can go to seek housing assistance. And then the case is going to be automatically, regardless of anything else, continued for 2 weeks. And then everyone's going to come back 2 weeks later, and then there's going to be the eviction hearing, assuming the tenant doesn't fill in the CARES Act declaration. And then the question will be whether the courts give us the opportunity to cross-examine the declarant on the CARES Act. And then if they do, whether we are able to, get that declaration found to be good or bad or well taken or not. So it's going to be, I'm not allowed to criticize courts or judiciary, but it's going to be a little bit of a flea circus for a while till we figure it out. So Kentucky's going to be a bit of a wild ride. They've made it very, 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 very tough on landlords since March, and I don't think they're going to make it a lot easier. Even though Governor Beshear did back down on all of his other orders as part of a, settlement of the Greater Cincinnati Northern Kentucky Apartment Association's lawsuit against Governor Beshear, sort of as a reflection of the CDC's orders. The Apartment Association spent a lot of money to get to this point, which doesn't seem like a lot, but it's a lot compared to where we were. It's still going to be a very tough road to hoe to get an eviction in Kentucky, but at least we're getting somewhere. It's better than nowhere, but it's now going to be a 2-part process, and we're going to see how these CDC declarations are handled by the judges. And I think all the counties are going to handle it differently, and we just don't know. And I think it's going to change a little bit. I think one district or one county may copy another county for a while, and I think judges are going to just handle it differently. And I just don't know. And unfortunately, I don't think anyone knows. I think the Boone County judges were very open to the idea of allowing us to now at least examine these affiants or declarants before they decide to take these declarations. I think Judge Blau was open to it in Campbell County. I just don't know what the Kenton County judges are going to do. And I just don't know what further south is going to do either. We just haven't had any experience down there yet. This is all 2 weeks old at best. And this new process is going to throw another wrench into it starting on Monday. So I'm sorry, I don't mean to not answer your question, but there's just not a lot of information yet.
All right, another question from Ginger. Do we have to accept a written statement from the resident not on the form? What if a resident verbally declares they cannot pay per the CDC declaration? Do we have to accept?
Well, there's not really a form. I mean, they have to declare these things, or at least some of these things, in writing under the penalty of perjury. I don't know they have to declare all of them, but if they choose to declare 1 or 2, then I guess we get to examine them on them. I don't think they have to, we don't know whether they have to declare each and every one of them, because if they don't agree with all of them, we don't know. We believe they have to declare each and every one of them, but we don't know what a judge is going to do if some of them aren't true, but one is true. We don't know if it's an all or nothing proposition. If they're not afraid of becoming homeless, but they've used all their best efforts to get government housing assistance, I still think we would be able to proceed, right? So I think they have to declare all of them. So I think they do have to use, I think what they have to use is, they can make up their own form, but I think they have to contain everything on the form. Now, if they declare it orally, that would appear to me to not meet the requirements, right? I mean, it does have to be in writing under the penalty of perjury. So I don't think a judge would accept it orally.
All right, another
The judge
question.
would be happy to hand them a form to sign.
Another question from Andrea. She says, with student housing and most of the residents having guarantors, with the restrictions of the CDC declaration form, does it include their income of the $99,000?
I'm sorry, what was the question?
With student housing and most of the residents having guarantors, with the restrictions of the CDC declaration form, does it include their income of the 99,000?
I don't believe so, because the moratorium appears to talk about all residents of the household, not guarantors. Again, that's my best guess.
Along those lines, Jeff, would you clarify again? You went through that list of, if you received a stimulus check, just clarify along the lines, because it was a little unsure. I had somebody else text me on this. Are they included or excluded from filing?
This is the language, right? I either expect to earn no more than a certain amount of money, was not required to report income, or received an economic impact stimulus check. So, you could read it either way. I think it's if they received an economic impact stimulus check. I don't know. The more I read it, the more I think that if they received an economic income stimulus check, that they are eligible to give you this declaration.
That's what I took it as.
Okay.
That
Yeah.
was my understanding, and I wanted to make sure.
I read this every time, and I get more and more confused by that one.
I think the stimulus piece has to do about the dollars too, because there was a caveat on the to receive the stimulus check that you had to make less than that
Right.
same dollars.
So I think it's the same test, because I guess you don't get a stimulus check if you made more than $99,000 or something. So I guess it's just another way of vetting that test. By the way, Dave Donnet was nice enough to respond, because he doesn't have a mic on his computer. He did agree essentially that you can use a 30-day notice with the mandatory 3-day notice language built into it, and then not use a 3-day, or you can serve a 3-day after your 30-day. It's a business decision which way you want to go. So I think we were in agreement on that. Thanks, Dave.
All right, and the final question I see is, if a resident does not serve the landlord with any declaration but does not pay rent, is it business as usual with a 3-day?
Angela, if you are a non-CARES Act property and you do not receive rent and you serve a 3-day and you file and you go to court, and at no time are you served with the declaration, in Ohio, it's business as usual. And that's why moratorium sounds like such a funny word right now. But at any time after you file, or even before you file, you could be served with that CDC declaration. If it's before you file, there's no filing. If it's after you file, we're going to go to court and ask these questions. If it's after you file and you get a writ, and then between getting your writ and the set out, then we're going to have to go back to court and set it on a docket to try to get your writ reestablished, because the court's going to stop your writ from being enforced because you got served with the declaration between your eviction and your set out. If it's after your set out, I think you're okay, but I'm not even sure anymore. And this is why I miss Zantac so much since it's been taken off the market. I wish it were back.
All right. And our illustrious president, Don Bruner, has joined us. Don, I don't know if you want to kind of give some wrap-up comments.
Yeah, I'm sorry, unexpected. I couldn't be on today. Sorry about that. I can't thank Jeff and Charles enough for being here today, and the association putting this together. We're all in this together. We're trying to answer questions best we can for everybody. We are trying to work through this. As always, we share information and ideas, and that's why we're here today. I will tell you that from an NAA perspective, we are joining a lawsuit against the CDC. So I'm not sure as far as where it's already filed in Atlanta in federal court. So we're joining that suit. I will update you as we get closer to a hearing to know what that's going on. But the best we can do is just work together and try to work through. And if this new process with Kentucky continues, maybe we'll just have to reinstitute where we were before or make a modification to what we were doing before. I mean, we have to be able to continue as best we can to business as usual. So there is some money that's available. Charles, did you go through some of the money that's out there as well that we talked about earlier on the OAA call?
I did touch on the fact that there's support services out there, but those resources are also available on the association website.
Right.
City of Cincinnati's put in $500,000. There's $5 million from the county, and then we also mentioned that there's actually the county commissioners for Hamilton have actually secured about another 2 to 3. They're willing to go up to $5 million additional funds. And actually, as we just heard on that OAA call this morning, there's additional funds that are at the state level that will be going out to municipalities. And this is where I'd encourage you to reach out to your local municipalities. They can use those funds as rental assistance as well.
Those funds have to be for COVID related expenses,
Correct.
non just budget fillers. So this obviously would be that. So we'll we'll try to work through as best we can as on many of these things, and so we come up with. I would watch out on the Team Kentucky funds. There are just everybody's. There is a caveat in the Team Kentucky money. I know this is a lot of Ohio calls, but anybody with Kentucky properties, Team Kentucky, you have to. There's a 10% haircut, and I think it's then 45 days to file evictions in the future. So as you're getting some of the money from some of these municipalities, please dig in to make sure any of the fine, small, little bitty print that you understand what you're signing on to. Not that you might not want to go ahead and take the 10% loss there, but just so you know and aren't expecting full payment. So, and I'm sure that 10% is not something you can recoup later if you file. So
Please remember that Team Kentucky money is voluntary. If your tenant tells you you have to take it, or you have to take it because of the CDC moratorium, it is voluntary. Now, you might not meet one of these tests now that I've tried to get federal housing assistance, but you don't have to take a 10% haircut just because it comes from state government. I'll put in one final plug. Elections matter. If you happen to know your federal senators, congressmen, if people are asking you for money, etc., rental housing assistance money through these CARES Act things is the most important thing you can be asking for your congressmen and senators to get through right now. I mean, you may have more important priorities yourself, but for this industry, this stuff has to get done, because without it, what's going on with us right now, it's just a drop in the bucket. I mean, the moratoriums hurt, but if there's no money to help these folks pay, it's just a big cliff. It's insane. It's scary.
well, thanks guys. Association for all this. Have a great weekend, and we'll see some of you at the golf outing on the 28th, and if not, we'll at the next GMM. So thank you very much.